All right, good morning, everyone. Welcome to the webinar. I'm Rana Spellacy. I am president of the National Association of Environmental Professionals, NAEP, and it is very early here in Seattle, so I'm still working on the coffee. I hope you all have coffee wherever you are and you're ready for a very exciting webinar this morning. I have been with HDR for my professional career of 17 years and involved in NAEP pretty much that entire time. So I again welcome you this morning, and we are very excited about this panel today, here to talk about an innovative law in New Jersey related to environmental justice. Next slide, please. So we'll be talking about New Jersey's new environmental law, and our speakers are listed here. Chris Whitehead will be our moderator. Again, welcome to our panelists and to all of our attendees this morning. Just wanted to make a plug for other events we have coming up here on the East Coast, or at least in the East Coast time zone. We have Advanced NEPA workshop coming up that you can check out on our website. As you all know, because you're here, environmental justice is a very salient topic in our industry right now. We're hearing so much about this. And so NAEP has created a working group related to environmental justice. If you're interested in joining our working group, you can find information on our website, and there's instructions shown here of how to join that. Very simple to join. The intent of our working groups is to provide a forum specific to a certain topic of interest, allow you to network with your colleagues across NAEP who also have interest and experience with that topic. And it allows us to really focus our energies on one of the many, many topics that NAEP members care about. So we welcome you to join that working group if you're interested. Also, just wanted to let you know about a new feature we have this year, our podcast, Environmental Professionals Radio. You can find our podcast on any of the apps used to listen to podcasts. It's hosted by Nick Frederick and Laura Thorne, and we cover a whole variety of topics and interests on the podcast. It's sort of a casual forum that allows us to get a little more creative in the topics and the types of things that we get into, subjects we get into, maybe not so formal as this format of a webinar or something like that. So I really hope that you'll check out the podcast at your convenience. It's very fun. And with that, Sadie, you can go to the next slide. Oh yes, the member benefits. Hopefully many or most or all of you are already members of NAEP. But if not, I would encourage you to check out the various benefits to our members. We have so many informational opportunities, publications, webinars like this, and many other topics, as well as our annual conference. So all of these things are provided free or at discounts to our members. And it just really is the best way to stay engaged in our environmental professionals community and stay abreast of the latest and greatest information in the regulatory realm. So I just really encourage you to consider becoming a member if you are not one already. With that, next slide, please. I would love to introduce our moderator for today's webinar, Chris Whitehead. Chris is with EnviroSciences. He's a senior air quality analyst there, air quality leader, has more than 15 years of experience in air quality analysis and related regulatory regimes, and more recently has been involved with environmental justice regulations and policy with regard to offshore wind projects in New England and the Mid-Atlantic region. We welcome Chris. Thank you so much for joining us today. And with that, I will turn over the mic to Chris to introduce the rest of our panelists.
Thank you very much for that introduction, Rona. It's a pleasure being here today, and it's been a labor of love, honestly, the last months putting this program together. But I'm very proud of it, and I look forward to an engaging conversation with what's honestly a dream panel of mine. As you said, I'm actually leader of environmental sciences air compliance practice. But first and foremost, I'm a New Jersey kid, born and raised. And over the last 15 years of my career, whether it's Hurricane Sandy or unfortunately the extreme weather we had come through last night, with the tornado coming within a mile of my house, actually, it's pretty evident to anyone paying attention that climate impacts are increasing at a very alarming rate. And we'll be touching on the topic during the conversation today, but I just wanted to put a quick pitch in at the beginning that I look forward to being a part of further conversations and greatly encourage their happening. So over the last 15 years of my being an environmental compliance consultant, I've seen a lot of regulatory changes. Over that time, you learn to identify the ones that have potential for transformational effect. And as a consultant, you have the responsibility to inform your clients of these regulatory changes, to advocate for fair and concise regulations during the stakeholder process, and to do everything you can to protect the environment. Last fall, as New Jersey passed the most comprehensive environmental justice law in history, many expected other states to follow suit and strengthen their own environmental justice programs. Today, we'll honor environmental justice champions, past and present. We'll go over the New Jersey environmental justice law, also what's happening in other states and with the Environmental Protection Agency, and finally, what can be reasonably expected in the environmental justice sector over the next couple of years. Joining us today are State Senator Troy Singleton, NJDEP Commissioner Sean LaTourette, Director of Office of Environmental Justice at Environmental Protection Agency, Matthew Tejada, and the Director of the Environmental Justice Clinic at Georgetown Law School, Sarah Colangelo. So, slide please, Sadie. Senator Troy Singleton has devoted his life to public service and has held various government, political, and policy posts in the state capitol since 2011. Senator Singleton serves as chairman of the Senate Community Urban Affairs Committee, vice chair of the Senate Economic Growth Committee, and as a member of the Senate Budget Committee and Judiciary Committee. During his time in the legislature, the senator has had a significant number of proposals signed into law and has received numerous awards for public service, legislative acumen from business, education, civic, labor, and nonprofit organizations. He's also one of the original sponsors of the New Jersey Environmental Justice Law. Thank you, Senator, for being here today. Next, we have Sean LaTourette, NJDEP Commissioner, who's responsible for formulating statewide environmental policy and directing programs that protect public health, ensure the quality of New Jersey's air, land, water, and natural and historic resources. A policymaker and lawyer by trade with more than 20 years of experience with environmental protection, Commissioner LaTourette began his career defending victims of toxic exposure, including organizing and advocating for the needs of vulnerable New Jersey communities whose drinking water was contaminated by petrochemicals. Throughout his career shaping environmental law and policy, he served in executive roles and as a trusted advisor to governments, community and nonprofit organizations, and leaders in industry and infrastructure, while also litigating high-stakes lawsuits involving environmental, energy, and public health concerns. Thank you, Commissioner. Next, we have Sarah Colangelo, Director of Environmental Law and Justice Clinic at Georgetown Law, where she teaches multiple courses in environmental law. Professor Colangelo's areas of specialty are environmental litigation and enforcement, including community considerations and the enforcement process. She speaks at conferences, appears in the media, and provides professional testimony on these topics. Before returning to Georgetown Law, her alma mater, Professor Colangelo, served as a trial attorney for the Environmental Enforcement Section of the Environment and Natural Resources Division at United States Department of Justice. At DOJ, Professor Colangelo managed complex civil and environmental enforcement cases for pollution control and cleanup of hazardous waste sites to negotiated or litigated resolution, appearing on behalf of the United States in trials across the country. Thank you, Sarah. And finally, we have Matthew Tejada, Director of Office of Environmental Justice at EPA, where he's currently responsible for all aspects of work of the Office of Environmental Justice and the EJ program, more generally throughout the agency and across the federal family. OEJ has external aspects such as community engagement, outreach, communication, and management of the National Environmental Justice Advisory Committee, of which he serves as designated federal official. OEJ encourages external partnerships with other federal, state, local, and tribal agencies in support of community initiatives. OEJ also supports and manages the work of the EJ Interagency Working Group and is instrumental in the planning and implementation of EPA's environmental justice strategy, the EJ 2020 Action Agenda. And OEJ supports the efforts of communities to address environmental justice challenges across the country through direct support, intervention, partnering, and the elevation of community voice. Now I'm gonna take a breath after that. And finally, before we get started, I'd like to go over a couple of housekeeping items for participating in today's webinar. All attendees are muted, and you can ask questions at any time by typing them into the questions section of your control panel. You may submit the questions anytime during the presentation, but we'll hold all questions from the audience till the end. During the presentation, I will be giving the panelists questions and also encouraging their comments to other panelists to try to encourage us to be as much of a natural discussion as possible to hopefully inspire other discussions on this very, very important topic going forward. The NAEP office is monitoring the question box throughout the presentation and will also be available to answer any questions on technical issues. Before we get started, environmental justice efforts in this country would not be where they are today if it wasn't for the work of countless community leaders around the country, past and present. Environmental justice advocates work hard to protect their communities and generally hate the spotlight, but their efforts and victories deserve some of it. Senator Singleton will honor some of these leaders and help us get started as he gives perspective on leading multiple environmental justice communities and sponsoring the environmental justice bill. At this time, there will be a brief pause as I switch screens. Longer pause, pardon me. All right, Senator Singleton, the floor is yours.
Thank you, Chris, and thank you to the National Association of Environmental Professionals for inviting me here to speak about New Jersey's environmental justice law and frankly hosting this important session on environmental justice. I am incredibly proud that New Jersey's environmental justice law is attracting attention as a model for environmental justice policy across our nation. But I would be remiss before we begin. It is critically important, I believe, that we recognize the many men and women who've championed this issue of environmental justice for so many years, many of whom who are listed on this slide that's presented before you. We would not be here today discussing this very important issue if it weren't for the work of many and all of these champions. Some of the names you'll recognize, like Greta Thunberg and Reverend Jesse Jackson and Reverend Barber, but they're all of such an importance of a national and international scope. But there are others who you may not know, but two played a critical role, especially here in New Jersey, in establishing our environmental justice law. In fact, the story of New Jersey's environmental justice law begins with advocates from the Ironbound Community Corporation and Clean Water Action, especially, who stood up for environmental justice and demanded, frankly, that their voices be heard. They and their neighbors and families were literally sick from the air and fumes they were breathing each and every day. And their tireless advocacy and dedication allowed us to achieve something that so many thought was impossible. For instance, my dear friend Kim Gaddy of Clean Water Action, who lives in Newark, New Jersey, and has been open about her family and hers lifelong struggles with asthma, which has been passed down to her children. She is someone, when the word tireless champion is ever looked upon, she is the epitome of a tireless champion. I was proud to stand shoulder to shoulder with her as we work to advance this idea into law. My other dear friend who I got to know so well during this journey, Maria Lopez Nunez, who lives in the Ironbound section of Newark. And she told me this story that struck me, and it sits with me, and I say it every time I talk about this issue. Her and her friends literally used to play a game where they would sit out on their stoop and try to identify which factory stench was polluting the air that day. And if you take a second and think back, that was a game young adults and children in Newark were playing because they just were not considered worthwhile to have a fight on their behalf. That so many of these polluting facilities were in their backyard. And every time when she told me that story, it just struck me to my core how important this fight is. Their anecdotes are just a snapshot of what millions of people across our nation live with every day. Asthma, lung cancer, respiratory infections, COPD. They're just some of the many ailments that are attributed to pollution. We all know that air pollution is directly associated with heart and lung issues, premature death, and respiratory issues. Adults living in urban areas are at a higher risk for complications than those living in rural areas and compared to much of the rest of the country. And New Jersey, for those who aren't familiar, is a mainly urban landscape, most densely populated state in our union. Nationally, more than 40% of US citizens live with unhealthy air, and frankly, many of whom are people of color. But in addition to advocates like Kim and Maria, this story could not be written without the champions in the legislature who championed, frankly, this issue long before I was a member of the legislature. Our Senate Majority Leader, who is retiring this year, one of the true lionesses of New Jersey's legislative history, Senator Loretta Weinberg, Senator Ron Rice, the former chairman of the Legislative Black Caucus, Assemblywoman Valerie Huddle, a dear and fierce advocate for environmental justice, as well on the national level, our U.S. Senator in New Jersey, Cory Booker, who put a national spotlight on this issue and continues that fight in the halls of Congress to have a national model, a national law put in place. Upon joining the Senate in 2018, I took over the mantle of leadership on this issue, and I introduced this legislation to provide the communities that are most affected by environmental justice policy to give them the voice that they have long deserved. So what does the law do? The law authorizes the New Jersey Department of Environmental Protection to evaluate the environmental and public health impacts of certain polluting facilities in overburdened communities. Under the law, these communities would be given an opportunity to voice their concerns during public hearings on the siting of future projects and will require the DEP to assess the environmental impacts to the area. Essentially, this law seeks to promote and build upon the type of host community engagement that some intensive facilities already undertake, but too many do not, by requiring community involvement in certain environmental permitting decisions. We estimate that there are 310 municipalities in New Jersey that have overburdened communities in them. Now, the phrase overburdened community is defined very clearly in the law. It means communities that have at least 35% of households that qualify as low income, at least 40% of residents must identify as minority or a member of a tribal community, or at least 40% of households would have limited English proficiency. And additionally, the community must house major sources of air pollution. The law applies to a specific set of facilities that may be proposed in low-income census block groups as determined by the latest census data. This is the most finite unit of neighborhood census data analysis. This unit of analysis was chosen to promote an application of the bill's requirements, focusing on those areas and communities that are in the most need. The bill seeks to identify existing environmental and public health stressors within a host community and instill a regulatory mechanism for resolving disproportionate impacts if such localized impacts are found to exist. I know my commissioner from the New Jersey Department of Environmental Protection and friend, Commissioner Latourette, will be discussing the law in greater detail and the work that he's doing to take the law through the regulatory process. But I hope this provides you with at least a framework of how our law is intended to work. One of the quotes that I often say about developing legislative policy is that every law has a season. And I think when you know about the ravages of environmental justice and what it does to the community, you're probably wondering why it took so long for New Jersey to finally enact this law. As I said, the journey started long before my involvement on this issue. And it's been a longer journey for advocates and a decade-long journey for the people living in these communities to make this way through, decade-long plus, to make this way through the legislature. But it's indisputable that timing was key to the law's passage. This legislation was something worked on for several years. And after years of waiting, we finally had the momentum needed to get this bill to the finish line. And I think that momentum was spurred a lot by what we saw with the tragic death of George Floyd murder last year in Minneapolis. As I said, at countless peaceful protests and rallies across our state, his murder and the Black Lives Matter movement was an opportunity to turn that moment in our country's history into a movement to create a more fair and just society, not just in a criminal justice aspect, but in every aspect of our society. Turning this pivotal moment in our history into a movement, one where Black Lives Matter and crafting not just police reform and not just education policy, but yes, in environmental justice regulations. This law is a key pillar, in my estimation, of us turning that conversation into concrete action. Governor Murphy announced his support of this bill on Juneteenth, 2020, and the bill was signed into law 3 months later. And though it seems like that's such a short period of time, we cannot lose sight of the fact that the struggle was more than a decade long to get us to that point. There has been, and there continues to be an urgency to get these issues resolved once and for all, because generations of New Jerseyans are continuing to have these adverse health effects due to the overabundant sitting of these toxic facilities in their neighborhoods. And none of this, absolutely none of this would have been possible without the passion, commitment, and dedication of advocates like Kim, Maria, Nikki Sheets, Dr. Nikki Sheets, and so many others from Clean Water Action, the Sierra Club, the League of Conservation Voters, to get this issue the attention that it needed. And their support spoke volumes against the opposition we faced from some who feared that this bill would impede economic development. And we cannot ignore that there was an economic and environmental reality that frames this debate. But history and experience tells us that environmental protection and environmental development are not mutually exclusive. That's a talking point that those who seek to deny the opportunity for communities that are faced with this burden to have the ability to articulate why they should say no more. And we're not going to abolish the market economy that drives these decisions, nor can we outlaw or pollution or equalize its incidences amongst our communities. However, we can and frankly must do is to do more to address the most egregious imbalances and risks that result from those with more financial resources and louder political voices, crowding out those who are bereft of both. This, which has created a concentration, frankly, of these facilities in lower socioeconomic communities and leading to documented adverse health conditions. This law will support, not undermine, sorely needed opportunities for growth and development in our overburdened communities and will ensure a greater commitment to public health in doing so. Lastly, but most importantly, is the idea that we started with and we continue to hold true to this day. No community should shoulder a greater environmental burden than environmental benefit. This law strikes that balance. It is my hope that it will truly serve as a model for the rest of our nation. Thank you.
Well, thank you very much, Senator. That was an extraordinary introduction. And now I have the honor of also introducing NJDEP Commissioner Charlotte Tourette, who's going to dive more into what exactly the New Jersey EJ law does. And then after the commissioner speaks, I'll have some questions for the panel on both of these topics. So with that, Commissioner.
Thank you very much, Chris. There we go. There's some slides. Thank you for those listening today. Thank you for joining us to talk about such an incredibly important topic, not just here in New Jersey, but throughout the country. I venture the world. I want to thank our hosts, the association, for bringing us together today, to you, Chris, for spearheading this conversation, and to my colleague and friend, Senator Singleton. Your advocacy has brought New Jersey to a better place. Your name should be on those slides of champions as well. And I'm grateful to be joined today by both friends from the EPA and from Georgetown. So quickly, I'll go through what this law does and doesn't do, because I think that too is important. I think that we need to be careful not to suggest or even pretend that while this law is powerful and important, we shouldn't pretend that it is a panacea for the issues that are faced by our low-income and largely minority Black and Brown communities throughout New Jersey that are known to bear, it is a fact, a disproportionate burden of the pollution that we all together create. So if we can go to the next slide, I'll walk you through how this law functions. So I won't read off the slides in any detail. I know folks joining us here today may have read the law or be familiar with its terms, but the first couple of slides here go through the findings and declarations, which are effectively an acknowledgement by the legislature and the governor of the state of New Jersey, to whom this law was incredibly important to see through. Acknowledging the fact that while despite the drive here in New Jersey to ensure a lived quality for all people, that our environment has, and the way that we pursue both development and the operation of industrial facilities has had a disproportionate impact upon overburdened communities, that there is a legacy, long legacy indeed, of citing those most highly polluting facilities in communities that do suffer from adverse health impacts associated with those types of facilities. And I'm not suggesting a direct causal relationship, but rather a proliferation of facilities that are known to have a higher impact upon public health and the environment in particular areas. We can go to the next slide. We start from this proposition that no community in New Jersey should suffer that disproportionate burden, that we have to provide folks with that meaningful opportunity to engage in the decision-making that results in facilities that are more highly polluting being located in their communities. But that meaningful involvement and participation in itself is not enough. That we have to provide, says the legislature, our environmental agency with the authority to look beyond what environmental law has historically done, which is to evaluate the potential impact upon air quality, for example, upon water quality by any one industrial facility or permitted facility, and look at the collective whole of underlying public health and environmental stressors within a host community in which a new facility, expanded facility, renewed facility is proposed, which is not something that in the last 50 years of the history of modern environmental law has been done. We look facility by facility. We examine whether or not a facility has the control technology required to meet a particular environmental standard, but we do not look at the impact of multiple stressors upon that host community, which is part of the reason that we have part of the reason that we find ourselves and that our fellow residents find themselves in communities that are subject to a proliferation of facilities and other stressors that impact their environment and their health. Next slide. But as I said, this law isn't a panacea. It doesn't address every issue that an overburdened community can face. But it is a darn good starting point where, through the process of stakeholder engagement, through being on the ground with communities for a very long time, as the senator said, this bill was in the legislature before his tenure, certainly before my tenure in state government. And through that process of working with communities, we identified facilities that have known implications within those communities. And the law went on to identify 8 types of facilities that would be subject to a heightened level of review at the time permits are requested from the Department of Environmental Protection. Major sources of air pollution, notably not minor sources. Incinerators and resource recovery facilities, sewage treatment plants and solid waste facilities, transfer stations, recycling facilities of a certain size, scrap metal facilities that we know are a cause of multiple issues to communities, nuisance and otherwise, fugitive dust being a huge part of that. Landfills and medical waste incinerators among them. If we can go to the next slide. And what the law fundamentally does is says upon submission of an application for a permit from my agency for any one of these covered 8 facilities, we're going to, in addition to conducting the usual environmental permitting review, examine the environmental and public health stressors that are already at work in the host community, and very specifically within the block group in which the facility is proposed. that it's census-based criteria as the senator had laid out. And we look at whether that facility, when proposed, will create or contribute to conditions that could cause a public health impact or an environmental impact that is disproportionate to those faced by another community. So it requires a comparative, not a causal, but a comparative analysis. As we'll get to in a moment as we go through the regulatory rulemaking process, we're evaluating the number and type of stressors that will be included in this analysis. If we go to the next slide, please. So just to back up a moment, what we identify in this legislation as an overburdened community is derived from demographic information. And one may say that demographic information alone, census data that identifies limited English proficiency, minority status, or income, relative income level, that those criteria in and of themselves do not make an EJ community. To those who say, who would think that, I'd agree. But it is important to have a baseline starting place because what effectively, at least in New Jersey's approach to EJ policy, makes an environmental justice community is the first demographic information that allows you to identify a community of concern, and then examining the proliferation of adverse environmental and public health stressors in the absence of environmental benefits. That intersectionality, a Venn diagram of community of concern, lack of environmental benefits, and presence of environmental stressors, that overlapping Venn diagram in the middle there is an EJ community. But in order to identify that, we have to start with the population that we know to be adversely impacted under the conditions that exist today. So we start with this identification of community block, of census block groups within the criteria you see here today. And some have remarked, well, gee, that looks like half of New Jersey's population. Yes, New Jersey is a diverse state. And so we have to look within all of these pockets where folks could be vulnerable to a disproportionate impact as our first level of screening. If we go to the next slide. And as I mentioned before, within these areas, and this map makes it a bit more easier to see, within these areas is where we will conduct this additional level of analysis through the creation of a number of things. Number one, a tool, a data analytics tool that we are developing now that will be deployed to assist communities, to assist the regulated community as well in identifying what public health and environmental stressors are present in a given community, how they are quantified, and how they are to be assessed in the course of performing what this legislation sets forth as an environmental justice impact statement, or an EJIS. And that level of analysis would be required to be conducted within all of the communities that are identified in the foundational demographic information in the legislation. We go to the next slide. And then we have to determine that point of comparison for analyzing the potential for a disproportionate impact. The bill's language, or the law's language rather, leaves that up to the agency to identify the appropriate geographic point of comparison. When we're looking at an affected community, and we're looking at that block group and evaluating whether or not there is a disproportionate impact posed by a new expanded or a new facility, and in order to derive that conclusion, that there is or is not a disproportionate impact, we must have a point of comparison to weigh that against. And there, throughout the course of our regulatory rulemaking process, we've been engaging with stakeholders and taking in the feedback from the regulated community, from folks in our EJ activist community, from environmental professionals, as to what point of comparison would be appropriate. Do we compare that to averages for the state? Do we compare that to areas that aren't overburdened? Do we do that within the county? Do we do that within the state as a whole? Do we do that in some hybrid approach similar to the US EPA's EJ screen using multiple geographic areas? And what is the proper comparison? For comparison purposes, what do we look at? What percentile ranking for screening and then for conclusion, for reaching a conclusion of disproportionate impact would be appropriate to use? And again, that's being determined in the course of our rulemaking process. We can go to the next slide. As I mentioned, one of the things that we're looking at in building a tool that will be publicly available, and our intent is to make that tool available for review at the time we propose a regulation. We're looking at the data that is available, publicly available information. We're looking at the quality of the data, its veracity, its scalability. And we began by looking at over 60 different environmental and public health stressors. And now as we've moved through this process, we're looking more so at around 30. We move next slide, please. As I mentioned before, the legislation requires the submission of this environmental justice impact statement. It requires the conducting of a public hearing within the overburdened community prior to submission of the application. And that is a bit of a paradigm shift insofar as what we are typically requiring in throughout most of our environmental regulatory scheme: public notice, opportunity for public comment, not always a public hearing. Usually a public hearing is granted or requested by the agency. Here, the public hearing is required as a matter of course. It's required not to be conducted in Trenton, the center part of New Jersey for those who aren't local here, when we know that folks on the ground are in an overburdened community are going to be least likely to have access to some hearing in the middle of the day in the state's capital. But at the same time, what we want to achieve here is some level of parallel processes so that we're not duplicating efforts, that we're not putting the regulated community through repetitive processes. So there's a lot of thought and attention as we go through the regulatory development process on that very point. Can we go to the next slide? And I think this legislation, it carries so much hope, and it should, it's important. I think it's a big deal. But it also does have limitations. Some have hailed it as the holy grail of cumulative impact analysis and the right of an agency, providing an agency like ours with the authority to deny an application where there's a cumulative impact. And that is true to an extent, but it doesn't require absolute denial of environmental permits for new facilities. It requires this greater weight, as I've described, as to the occurrence of disproportionate impacts. It does not allow the agency to deny permits for renewals of existing facilities or expansions. It does allow the agency to consider conditions, additional conditions beyond our standard conditions, site-specific conditions that would be of usual course. And it doesn't seek to promote delay or duplicative process I just mentioned before. And it doesn't reach beyond the facilities that are covered by as they are covered by underlying environmental law. Our implementation of the Clean Air Act here in New Jersey, or our state's own Air Pollution Control Act. It doesn't reach beyond the confines of the Clean Water Act or our own Water Pollution Control Act. It is not new substantive environmental law in that respect. And it certainly doesn't contravene local land use authority, which is one of the most bedeviling factors leading to some of the environmental injustices that we see throughout New Jersey and the country. Go to the next slide. So where have we been and where are we going? This law was signed, the legislation was signed into law almost a year ago, last September. We immediately began our rulemaking process. We've done a lot of data evaluation in the course of working with the senator on the legislation itself for 2 years prior to its finding the moment he described. So we immediately launched our stakeholdering process and then dove specifically into, over the course of the last year, specific issues with our stakeholders on that geographic point of comparison, on the conditions, on the nature, extent, and issues to be explored within the environmental justice impact statement. And we wrapped just 2 months ago our final stakeholder process, and now we're culling through all of the feedback and actually diving into the writing of the regulations as we are developing that data analytics tool. And we expect that we'll have a formal rule proposal this fall, and that will move toward adoption of this important regulatory scheme early next year. So that's a brief view of where we are, and happy to talk with you all further. Thank you for joining us today.
Well, thank you. Thank you, Commissioner LaTourette, for the very solid overview. I have a number of questions for both you and Senator. And I'd like
Chris, did you want to take down the slides? I'm sorry, I can't do that.
I can do that, sure, no problem. I have a number of questions for you and the Senator, and I would like to also invite the other two panelists to jump on and comment if they see fit, but most of these will be for you directly. I'd like to start off with Senator Singleton. Can you give me a little bit of background into the bill making process and the amount of time and coordination that was done speaking to various experts in the field? And thank you, by the way, for already touching on why this was the right time for this bill to get through and how it went through. But any background you can give me on the, lack of a better term, homework that was done to craft the bill, I think that'd be valuable.
Yeah, thank you, Chris. I don't usually give the secret sauce up, but for you, I'll make an exception.
I appreciate it.
Honestly, I think the work on this was one of real collaboration, and the commissioner talked about it, and I think he said it far more eloquently than I. We recognize this is not a panacea, and in the legislative process, you don't always get what you want, but you try and create at least a line that you're not willing to go beyond and go backwards on. And I think once we establish that amongst the advocate community, especially who've been fighting for this for, as I said, well over a decade, then that allowed us to have some flexibility with working with not only the administration, Governor Murphy's administration and the commissioner and others, but also working with those who didn't see the process the same way that we did. And talk them through sort of where the push points and the ability to give relied upon in certain particular areas and where some other areas it didn't. And I give you a big example. One of the examples was on the where DEP's role comes in on permitting, whether it's permitting for new facilities and permitting for existing expansions. That was an area where there was great compromise on all sides to be able to get us something that ultimately the governor can sign. There were some who said, well, if I already have a facility and I'm just expanding it, this shouldn't even apply to me. And many of us pushed back and said, well, no, we're not going to allow that to happen. If you're expanding it and expansion causes a negative cumulative impact, then you should have some ability to have DEP to weigh in. And where we ended up at was the DEP has the ability under this law to create conditions upon that expansion, which we thought was a reasonable compromise. If they say through the use of new technology that the commissioner and his team deems can be appropriate for an expansion that needs to be implemented into an expanded facility, DEP is within its bounds under the construct of this laws to actually make that happen. That's just one example. There were several others of the idea of trying to bring people together and sit around the table and even during the COVID timeline and have that conversation and have folks recognize a fundamental point that I live by. There are no monopoly on good ideas. Like, we all have them. And if you think about it from that construct, you sit down, our abilities to try and get to yes. And that's what we did. We kept bringing people together, kept having conversations and dialogue, not letting individuals silo themselves off and put up these impenetrable walls to say, I won't go beyond this point. We're able to move down the barriers and come to a conclusion of trying to get something done. And that was how we did it.
I appreciate that. And I definitely agree it's a valuable process, and definitely appreciate the fact that you tried to gain as much input as you could from your local stakeholders. As leader of the criminal justice area, you obviously have a lot of input to gain from people in the actual community itself, whether it's the business owners, the affected minority populations, et cetera. So I appreciate that very much. Just as a little bit of a follow-up, Senator, I know that you've been recently sponsor or co-sponsor of a number of bills to do various things like taking out lead lines in the country, actually improving broadband capabilities, that kind of thing. How do those bills complement the efforts that the environmental justice law is trying to affect?
Well, they're all interconnected, right? So let's talk quickly about the lead lines bill. In New Jersey now, we'll have a process based on the law that we got passed. That was probably one of the main prime sponsors of, and the governor signed, to allow over the next decade, within 10 years, to have a process to remove all lead lines, all lead service lines in our state. We know the disproportionate impact that lead service lines in many older stock homes that are primarily a lot of our urban areas, primarily a lot of in our poor urban areas, and what they have on the emotional and developmental capabilities of children who drink water through lead infused lines. So our ability to, again, to work together, utilities, the business community, local advocates, putting people together to say, we're going to solve this. So you don't, and I think that's the premise we start from. We are going to solve this. So you don't have the ability to put up barriers just to run out the clock, because we are going to solve this. And once you get everyone in that accord, then the rest of it is sort of fitting the jigsaw puzzle together. And it's high bars to the concept of environmental justice, because environmental justice takes many forms. It's not just in air pollution. It is in our water quality. To me, there's some level of justice and social equity with respect to the expansion of community broadband, which is also what we've worked on in our state. And I want to applaud President Biden and the Congress for an American Recovery Plan. One of the very specific uses of ARP dollars is for the expansion of community broadband. And one of the things we realized was so many families working remote, with kids having to do remote schooling, there's an inequity in the ability of the internet to make its way through different communities in our state. And the idea of having a greater community broadband infrastructure takes some of that social inequity away and allows our children, especially, to have the opportunities, whether they live in the richest hamlet in New Jersey or the poorest, to have an equal opportunity for that education. So all of these things are layered upon each other as precepts of justice, environmental justice, educational justice, and they're all tie-barred together.
Thank you. I appreciate that. And let's see, Commissioner LaTourette, I scheduled this webinar at the time that I did, in part to coincide roughly with the 1-year anniversary of the bill being signed into law, and to get past all this stakeholdering that's been occurring in New Jersey. Can you speak a little bit on that process and how you try to be sure you get input from the regulatory community, from the regulated community, and how you might get past or actually resolve conflicts that might come up if people don't actually agree with what you're trying to do?
Well, that never happens. I only ever make good decisions that everyone agrees with. It's never controversial, and we all always go home happy. But in all seriousness, I think that, and I believe many of my friends in the regulated community would agree with this statement, that the process we have run over the last year, the deep level of engagement on very finite regulatory issues has really brought people in. And it has helped to create an interface that I think is important for our community activists to engage with the regulated community and their professionals, and maybe understand each other a little bit more as a result. I don't think New Jersey's full of bad actors, industries that are just looking to pass the buck off on some community. I think I think the problems that we face are largely a function of the system we have set up, the collective we, societally. And the only way we improve upon that is by helping to one another to understand each other and the roles we respectively play in that. Much like this law isn't a panacea, it's not going to fix everything. By facilitating that conversation, much like the senator did around the table in crafting the legislation, maybe those community members will know better how to engage with the industries in their neighborhoods and vice versa. And I think that's a really important thing that's come out of it. And no, we're not going to make everyone happy. The regulated community may not agree ultimately with the way that we have determined best to rank environmental public health stressors and how we conduct that disproportionate impact analysis. They may not agree with that. In fact, they may sue me for it. But they were brought in to be part of that process. They had thoughtful things to contribute. And they know their clients, they know their industries. They can help inform and shape the direction of the regulatory structure. And I think that's been really valuable.
Now, there are a number of affected facilities on the list that you just shared. I think it was 8 or 9. Can you speak quickly about how that list itself was developed? And then as a follow-up to that, the senator brought up a very important term, cumulative impacts. And why are cumulative impacts defined as only negative impacts? To be cumulative, doesn't it also have to take into account various positive impacts that the site could have?
So I think that's the last question there, Chris, is an interesting one. Yes, there are 8 facility types that are covered. Within that 8 facility types, there could be different operations. This law will extend to major sources of air pollution, so Title V facilities. We have around 220 or so such facilities in New Jersey. Notably, only about 5 have newly been permitted in New Jersey over the last 5 to 7 years, I believe. So we're not getting a lot of new Title V facilities in this state. We are, of course, dealing with the renewal of applications for existing Title V facilities. As the senator pointed out, those permits can't be denied, but they could be conditioned. So when we talk about cumulative impacts, I think you'll note that one of the things that is unique, I think, about this law is that we're talking about disproportionality, right? We're not talking about causality. And I think that that's really important. And from I'm an environmental lawyer by background, that was a really important distinction for us to work through in the bill making process. And so we're looking at the relative degrees of stressors that could be presented by a new facility, how they interrelate to stressors that already exist in the host community versus those that are present in the community to which this application is compared to, right? And so when we say, do we look at cumulative benefits? What type of cumulative benefits are we talking about? The law requires us to look at public health and environmental stressors. If a facility is going to present an improvement of a public health and environmental stressor that is within the ambit of what we identify in the regs, then yes, sure, that should be evaluated. But if what we're talking about is the influx of jobs, for example, that may come with the development of some new facility subject to this law, no, that is not counted. and for every good reason, right? I couldn't tell you the number of times an applicant comes before DEP to tell us about all the great economic development benefits of a particular facility. And yes, societally, that is important. But environmental law, the statutes and regulations that I'm charged with executing do not care. It doesn't matter if a facility is going to bring 500 new jobs if it has an influx of particulate matter that's going to impair the air quality in a local community. And this law is going to have us look harder at that question and not at all at the economics, right? That's not part of the environmental regulatory process, period. Doesn't mean it's not important, but it's not what drives this.
As a follow-up to that, there's some in New Jersey who want the EGIS process to only begin if there's a net increase in stressors. Major modifications, major renewals, things of that sort. If DEP goes down that path, isn't that only keeping things from getting worse instead of addressing what's already happening?
So I think this entire law is about not letting things get worse, right? So what we're talking about here is the reduction of additional harm from from the perspective of additional environmental and public health stressors. There are multiple other ways outside of this law, ways that are being pursued under Governor Murphy's Executive Order 23, which is not unlike the order that President Biden had put out, and that I know EPA is working real hard on with respect to Justice 40, and how you improve baseline conditions and deliver environmental benefits. But that's a different work stream. This law is about making sure that we are not adding to the problem by looking at the problem that's there, which we don't take full stock of the problem that's there in the existing paradigm.
I'm going to talk quickly about another point you brought up, geographic points of comparison. And hypothetically, just if you want to actually play this out with me a little bit, two sites in New Jersey with almost identical operations. One site in an overburdened community might have permit conditions put on them by this law that the other site is not going to have. Is that fair?
That is definitely a possibility. Because it is about protecting the community, right? It's about protecting the community from further environmental degradation that also has repercussions for public health. And we're going to look at the conditions in the host community. So two different host communities with different conditions. And even if the same facility were proposed in each, there could end up being a different level of, there could end up being different conditions on those respective permits, assuming a permit were appropriate in the first place. That's a possibility.
Now, just also laying that out a little more. If you just focus on the site that might have permit conditions placed on them, if they surpass various stressors, is there going to be, this isn't a good term for it, but I'm going to call it penalty schedule, where the large aggressors, the large violators might have stricter permit conditions put on them than hypothetically if someone just barely goes over your statistical threshold?
Well, I think we're mixing a little bit permitting authority with enforcement and enforcement discretion in the penalty matrix. I think those are really distinct lines of policy, and happy to talk about the enforcement side, but I don't think that really comes into play on the permitting side.
That's fair. I have two more for this section. There are already various environmental standards in place. Just taking a couple that are that I know pretty well from my background in air compliance, whether it be NESHAPs or NAAQS, they're established standards that are there to protect human health. If they're already in place, why do we need environmental justice laws?
Because communities are disproportionately impacted, and it is a fact, and we can do better. And this law is going to require us to do better. And quite honestly, I think the regulated community in this state is with us. I think that we have a regulated community in New Jersey that wants to do as well by its host communities as it possibly can. And I've talked with many of them who see this law as a codification of the good neighbor principle. And for those folks in the regulated community, this type of a law takes their corporate social responsibility program and turns it into an enforceable legal matter. I think it's good for the regulated community and will amplify the good efforts of those who do such things. And it's definitely good for the communities that have been the recipients of the worst types of pollution for far too long.
As part of the answer you just gave, you touched on an interesting point I wanted to also touch quickly. How do you factor in potential pollution from other states? Example, how do we factor in what's coming in from Pennsylvania or, I don't know, West Virginia as part of the background ambient air conditions in my township of Burlington? And how do we separate that in our environmental justice impact calculations?
I don't think you do, because it's a baseline condition of the community in which the new facility or expanded facility, renewed facility is proposed. So those existing air quality conditions would be part of the baseline analysis about what's there already. And when we get to a point of unveiling our data analytics tool, you'll see how that comes into play.
Just one final question for this section. Pardon me. There are a number of environmental laws that have an economic and feasibility carve out, whether it's a dollars per ton figure or something along those lines. Why is that not included here?
If you don't mind, I'll start on that one, Chris, if it's okay. I think, and it goes to what the commissioner talked about, we are starting from a premise of focusing on the community's environmental health. And while we recognize that there are both an environmental and economic paradigm to these decisions, I think we made the decision to start in what is in the best interest of the community's environmental health. And because of that, the economic question becomes secondary in that discussion. Now, as we talk through and the regulatory process will evolve and what the potential enforcement and penalty section will look like, I leave that for others. But the fundamental point of why the actual law does not condition upon an economic discussion is because we really wanted to start from the premise of what we can do to secure and maintain and enhance, frankly, the environmental health of overburdened communities.
That definitely makes sense. And then thank you, Senator. And just as one final wrap up on that point, definition of environmental justice area includes, as part of the Venn diagram you mentioned, Sean, the presence or absence of public health benefits, whether it's public parks or various transit or access, things like that. Does that kind of hint at the potential availability for affected sites to do supplemental environmental projects as part of a compliance plan going forward to improve those conditions within the EJ area?
If there is an entity in the regulated community that has environmental violations that they wish to cure, with the supplemental environmental project. As part of that compliance, I'm here for it, but it's still not part of the permitting paradigm, right? That's part of the enforcement. I think what you may be getting at though is the idea of, can we offset environmental harm with an environmental benefit? No. Do no harm, or at least do less.
Well, thank you both. I think that was a very good session. And Senator Singleton, I know you have to drop off here. Just wanted to say I appreciate very much your time and your contributions to our panel. So thank you.
Thank you very much. Take care, Chris. Take care, everyone.
And with that, I'm going to share my screen again. And just give me a heads up if you can see it, please.
Yes, we can see your screen.
Thank you, Sadie. And now I have the pleasure to introduce Professor Sarah Colangelo from the Georgetown Law Center, who's going to touch on various other state actions right now and a couple other very, very important points. So thank you, Sarah.
Thank you, Chris, so much. Hello, everyone. Thank you to the National Association of Environmental Professionals for having me speak here today. Thank you to everyone who's tuning in. And I hope everyone's families are doing okay in the wake of the terrible storms that have passed through really the entirety of the East Coast in the last 24 to 48 hours. So as you've heard from some of my distinguished co-panelists, this is an incredibly unique and exciting time for subnational novel action on environmental justice. So I'm excited to speak about that today. And we can go to the first slide, Chris. Okay, so my goal for today as part of this panel is to, and the outsider who's not from New Jersey, but my husband is from New Jersey. So I do have a connection there. I'll tell you what exit off the parkway later. So as part of this panel, I want to contextualize New Jersey's environmental justice law, situating the law within the broader framework of state progress in this policy arena, discussing the types of legal strategies or what we might call regulatory modalities used by different states, and then highlighting both the benefits and shortcomings of having decentralized, varied policies across different states, as opposed to something like a monolithic federal environmental justice law. We can go to the next slide, please, Chris. So let's put this a bit in context. I think the senator said it so well. Every law has a season, I think is what he said. And right now, the flourishing of environmental justice legislation has been driven both by the individual advocates that the senator so powerfully highlighted, I think, but also significant recent developments, which was the case for most of our federal environmental laws developed in the 70s. But today, our catalysts for environmental justice state legislation are a society-wide focus on persistent systemic racial disparities in civil rights and in public health, which of course includes the brutal effects of COVID-19 on already vulnerable populations and underserved communities. An increase in social awareness of communities bearing a disproportionate burden of environmental stressors stemming from legacy pollution, as well as the siting of undesirable land uses, failing infrastructure, and attendant epidemiological and ecological harms. Advancements in data collection and visualization, and you've heard multiple both Commissioner LaTourette and the senator both mentioned a lot of these factors, but I really think these advancements in data are quite a critical piece. And this expansion in the demographic and environmental mapping tools designed increasingly with a user interface that the public as well as agency experts can engage with is going to be a very powerful force to empower public participation, and it's certainly already galvanized action in many areas. And of course, federal inertia. I won't press that too much, but I think federal inertia in this area has been one of the drivers for novel state action. We can go to the next slide, Chris. Thank you so much. Okay, so with that background, let's focus on the framework of state environmental justice legislation that's developed and is developing quite rapidly. So on the right here, I've put up a cover of an old report from 2004 of a 50-state survey from the ABA and the Hastings College of Law. But of course, we could reach back so much further than that for people demanding action at the state level. It hasn't been mentioned yet, but of course, the Toxic Waste and Race report. And we're actually approaching the 30th anniversary of the first National People of Color Environmental Leadership Summit, which was held in October 1991, where the foundational 17 principles of environmental justice were drafted and adopted. So over time, many states have included some reference to environmental justice. And that makes it a little bit tricky to necessarily categorize some of this legislation as new. So for instance, some states have maintained advisory groups or a draft environmental justice plan or created agency policy guidance. But now we're seeing states take a more comprehensive look at this issue. And that was really reflected, I think, in some of Sean's remarks. And New Jersey is really raising the bar here in quite a significant way. And before I dive into some of the features of state legislation, I wanted to underscore the pace of the development of these policies. And the numbers were actually changing quite quickly this summer as I was curating my own list of state actions. But we saw approximately 20 separate pieces of environmental justice legislation proposed in 2021. Sometimes there were multiple proposals in the same state. And there were about 5 pieces of legislation enacted in 2020 and approximately 10 in 2021. So you see the pace is rapidly increasing. And again, I caveat my remarks that there's flux in the summertime once depending on the legislative season, but I think we can still tease out a few thematic elements here that are worth digging into. Can we go to the next slide, please, Chris? Thank you. So here's a great, more novel visual map for you. And this is where we were at in March of 2021. And this map was generated by Bloomberg from an article by Dylan Bruce. And just since this map was generated in March, 4 states have turned blue and at least 2 added to their current legislation, blue representing states where environmental justice legislation was actually enacted. And when we look across all of this legislation, their structure, substance, and scope do vary quite a bit. But I'd suggest we can identify about 5 regulatory strategies employed in the environmental justice laws. Some states only pursue one modality, and some, like New Jersey, adopt a multifaceted approach and incorporate several of these components, okay? But as an initial matter, almost every piece of legislation proposed or enacted in the last 2 years includes what I term broadly an information clearinghouse on environmental justice related demographics and environmental statistics by locality. Some use a zip code, and hopefully more are using the census tract method, as I think it was the senator talked about just how important using that more granular and detailed specific level of analysis is when we're looking at demographic data and environmental stressors. And most legislation requires information gathering and processing, if not, again, visualizing the data and mapping it, making that mapping publicly available. This obligation is usually accompanied by the creation of a designated working group. So states might term them as an interagency environmental justice response team like Michigan, an environmental justice commission like in Maryland, and the language in one of the pending pieces of legislation in Georgia, or an environmental advisory council, environmental justice advisory council like in Virginia, and a bill just introduced in Texas, or a task force like Oregon, which also requires that members, to the greatest extent practicable, represent communities of color, low income, and geographically diverse state populations. Beyond curating data, these committees might also conduct a variety of functions, advising, and you heard some of this reflected earlier, advising state agencies, evaluating current state laws for disparate impacts on overburdened communities, reporting on the progress of state agencies or actors towards any established goals, and or being charged with interacting with underrepresented populations, including tribal governments, on environmental justice issues. Further, several state laws would establish funding mechanisms for remediation of legacy pollution or other environmentally beneficial projects, including investments in the deployment of clean energy. The funding sources differ depending on the law. So some generate funds from market mechanisms such as a cap and trade system like California does, and some, like Pennsylvania's legislation that was in committee this summer, would create an environmental justice communities trust fund to be used for mitigation projects. Many states also, and this is quite critical, I think, include a requirement for enhanced public participation for either agency decision makers or permit applicants, or both. So for example, Colorado requires that their Air Quality Control Commission promote outreach to disproportionately impacted communities. Connecticut requires applicants for a permit or siting approval from their Department of Energy and Environmental Protections that affects or is proposed to be in an environmental justice community to file a meaningful public participation plan. Then, as has been the focus of some of the prior remarks, a handful of states, and of course notably New Jersey, include what I would term agency or permittee mandates. And by mandates, I mean that the laws actually require agencies to develop environmental justice assessments for significant actions and require agencies to identify ways to reduce harms to overburdened communities to the greatest extent possible. So we saw that, for example, enacted this year in Washington State. Others require the permit applicants to identify and evaluate significant adverse impacts of facilities in what some pieces of legislation call environmental justice communities or areas, and to take specific measures to avoid impacts in order to receive a permit. And some involve both spheres of players, as it does in New Jersey. And it's worth noting, I think, that multiple pieces of legislation introduced in 2021, but yet not yet enacted, contained these type of mandates. So maybe we're seeing a little bit of that New Jersey influencing other states here. A bill in Georgia, for example, would require permit seekers to provide something like an environmental impact statement, specifically addressing environmental justice concerns. And we saw similar bills proposed in Massachusetts, Michigan, and Minnesota. A piece of proposed legislation in committee, I think in North Carolina, the last time I checked, would require state agencies to consider the cumulative impacts of proposed permits on overburdened communities and provide for enhanced public participation in that permitting process. And as a concluding observation here, I think it's worth noting that a small group of these states is creating a specific linkage in their legislation between greenhouse gas reduction and environmental justice. And we could do a whole separate panel perhaps on climate justice. But for instance, New York requires all actions taken by the state to mitigate greenhouse gas emissions should prioritize the health and safety of disadvantaged communities. Massachusetts similarly requires the state to set and achieve emissions reductions to the extent and in a manner that protects environmental justice populations. I think it's a logical linkage to be sure, but it's also interesting because it marries these two areas of federal inaction. Or we could say federal, and some might say federal inertia. So speaking of federal action or inaction, Chris, can we go to the next slide, please? Okay, so looking at all this progressive subnational action, one obvious question is, well, what about a federal law on environmental justice? So even though this panel is focused on state action, I think we do need to acknowledge that there remains strong rationales for centralized government-wide policies and legislation in certain fields, especially in environmental law. So what I'll do today is just run through some commonly accepted theories, probably quite applicable here in what is admittedly very, very broad brush due to timing. So information scaling is one rationale here. Effective regulation, especially in scientifically complex arenas, can require the collection and processing of vast quantities of data. So large governmental organizations are often better suited to that task. Transaction costs. If establishing or influencing policies requires collective action, and it does here. You heard the senator talk about all that action by individuals that had to go into making this bill happen. This can disadvantage underrepresented demographics due to resource, information, and power or influence asymmetries. Federal policy allows organizers or communities to compete in one venue instead of trying to influence policy in hundreds of jurisdictions across the country. Pollution mobility, this is an obvious one. Pollution externalities cross borders through air and water. So sometimes states have less incentive to abate their own interstate pollution caused by industries that form part of their tax base. There can be free rider problems. And this theory posits that states or localities might hope others will take the laboring oar to solve a problem or take on the burden of finding a solution, which can lead to lack of innovation and action. And finally, a concept that many of you have probably heard throughout your careers, something called race to the bottom, which is a theory that states might engage in potential competitive deregulation to incentivize businesses to stay in their states. So the next slide, please. Thank you, Chris. So with that frame, I think it's particularly going through those rationales, I think that really frames up again and underscores how exciting this time is. And I hope it serves to elevate and we can all appreciate that many of those obstacles I just listed were overcome here to produce innovative state action and are being overcome in other states as well. And I think that's, to me, that's really the animating or an animating feature of this particular panel. So I'd like to end my remarks today by highlighting some of the benefits of states seizing this mantle of action. And when states act as what judges and scholars sometimes call little laboratories of democracies, when states act as little laboratories of democracy, there's a chance for us to generate more effective innovation through experimentation because states pursue diverse strategies, not just one single strategy. And of course, this subnational action allows policymakers to account for geographic variables and ideally local preferences in designing these laws. There's also, I think, an important countervailing argument to the information gathering limitation I raised in the previous slide. Some scholars emphasize that decentralized action actually generates a greater diversity and quantity of information, which allows for leading states to inform other states and in turn influence one another's behavior. And while this point is arguable, I think some would say states have little incentive to generate information that would necessarily be relevant to others. I'd actually push back on that and say that may be less relevant of a critique here. So for example, my colleague Bill Busby has argued in a different environmental context that high visibility permitting battles can generate a tremendous amount of information that could be useful cross-jurisdictionally. So for example, what do I mean when I say that? We might imagine that the permit process that will unfold, that Sean really went through so beautifully, we can imagine that permit process that will unfold in New Jersey and other states with mandates that I spoke about they will start identifying and yielding advancements in terms of how to mitigate or reduce burdens in already disadvantaged communities. And the processes might equally inform community groups that are looking for blueprints for successful public participation. And then finally, critically here, state laws can also overcome federal gridlock and regulatory inertia, which is unfortunately a very real feature of our federal system, in particular Congress right now. So in marinating on New Jersey's law for this panel today, and as a national model, and digging into the survey of what other states were doing, I was reminded of this quote by Justice Brandeis that I've put up on the screen here, who was really articulating a sentiment that we have seen reflected for quite some time in jurisprudence, that it's a happy incident of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. Chris, the next slide, please. And so on that note, the final thought I'll leave you with is that we are seeing this novel experiment Justice Brandeis spoke about, but that it's actually of benefit to the entire country. And I don't see much risk here. I see a giant benefit to the rest of the country. And how far we go will depend on a lot of nuances of implementation. But right now, it's a really exciting time. And look forward to hearing from Matt and from all of you.
Well, thank you very much, Sarah. That was an excellent, very informative talk. And I just want to take a quick moment to thank you for the work you do with the Environmental Justice Clinic at Georgetown. I think it is an excellent benefit. So thank you. And with that, I have the honor of introducing our final speaker today, Director of EPA's Office of Environmental Justice, Matthew Tejada. And Matt, I think for time constraints, I'm gonna ask you to skip.
I'm gonna blow right through it, Chris.
That's fine with me. In that case, I will turn this off and kick it over to you.
All right. Hey everyone, thanks Chris, and thanks to the other panelists and everyone who's joined us today. I am going to go through this fairly quickly and hopefully answer one of the questions we already have in the Q&A from Dave about the impact of what the states are doing and what impact that has with us at the federal level, particularly at EPA. Just real quickly though, I wanted to mention one of the things that a lot of folks are curious about right now is the National Environmental Policy Act, NEPA, of 1969. It was something that the previous administration had pushed through some rules, potentially altering how NEPA is implemented. And I'm sure everyone on this call understands what NEPA is and the impact it has across the United States. And it's one of the two laws that were named in the original Executive Order 12898 back in 1994 on environmental justice. So if we go forward a slide, of course, CEQ, the Council on Environmental Quality, actually manages the NEPA process across all the federal government. EPA has a particular place within that where we review a lot of the analysis and decisions through a particular, not actually in the NEPA law, but it's actually another law that gives us the authority to do that. And that's important because NEPA is one of the few laws that really has some obvious space for practicing environmental justice, for looking for impacts, disproportionality, cumulative impacts. And that is something that I think we're going to see a re-examination of just how effective that authority and its application across the federal government is in this administration. You'll see here, this might make it look a little more complicated than it is, but there is a lot of opportunity within what happens within the NEPA process for folks to think about environmental justice, and also importantly for communities to have an opportunity to engage directly with decision makers Of course, folks are probably seeing this happen quite a bit around the country right now, particularly with some fairly controversial transportation projects across the United States, some port projects across the United States. There's going to be some energy things that are happening on the horizon that'll probably be coming up for some NEPA controversy. So if we can go ahead one more slide, we just wanted to point out that there is at the federal level, there's going to be a lot of discussion and hopefully I would imagine some public engagement and feedback around what we do with NEPA in this administration. So we keep going ahead. Yeah, and just a little bit of the limitations on NEPA. It does apply only to federal actions or to actions that have federal support or federal funding. It's procedural, it's not substantive. So if something happens in NEPA, it doesn't wrong or right a past wrong, but it can send you back in the process to address an issue, to address a disproportionality, to address the impacts of on a community from a particular decision that happens in NEPA, whether that is the actual substantive decision around where does a project take place, maybe a different option needed to be considered, or in terms of the sorts of mitigation that are offered to a community that maybe weren't fully addressed or whose concerns and impacts weren't fully addressed in an earlier stage of the process. It does not, though, have some sort of a penalty or some other like a different sort of enforcement provision as a lot of the other statutes do, where you would actually take civil or even criminal enforcement action. If we go ahead. So I wanted to very quickly cover just some of the things happening at the federal level, and I hope folks will hear in this a reflection of not just what is happening in the state of New Jersey, but really across the United States. To one of Sarah's points that she made, the states really have been very much in the lead on environmental justice in the United States, several states in particular. But I think what we're seeing now in the Biden-Harris administration with the leadership of Administrator Regan is EPA is making some of that ground up and is also looking to other parts of the regulatory endeavor, other states, tribes, local governments who sometimes hold our authorities, and looking for ways to raise the floor on environmental justice from the national perspective. So there are states out there like New Jersey raising the roof, and it's EPA's job to raise the floor. So if we can go ahead, just one slide. One of the first things that this administration has done on equity and environmental justice, the president on his first day, on January 20th, when he signed this executive order 13985 on advancing racial equity, it changed the paradigm of the federal government from the outset. The president and the vice president recognized that to advance equity, to advance justice, you can't just look at one agency or a handful of agencies to do it. It takes an all-of-government approach, and that all-of-government approach needs to be led by the White House, and it needs to include all of the government, all of the departments and agencies, and importantly, looking at our relationships with other levels of government, such as states and local and tribal governments. So this particular executive order really focuses on how do we advance equity across all of our practices, all of our governing. So each federal agency right now is actually working on this. We've already gone through the first deadline for it, where every agency did an equity assessment of the barriers to advancing equity. At EPA, we developed 6 work groups to kind of cover all of the different business streams and work streams of the agency. We had work groups on grants, on procurement, on data, on engagement, on, boy, I'm going to forget one, on policy, and that included permitting and rules and licensing. And the last one, I remember what I was talking, is research and science. So those 6 work groups have identified the barriers to us advancing equity across all of our work. We've turned that into the Domestic Policy Council of the White House. And now we're beginning to work on what is due by January, which is our plan for breaking through those barriers to advance equity across all of our business practices. And again, all of the agencies and departments across the federal government are doing this right now. If we advance another slide, this then 7 days into the president's term on January 27th, he signed another executive order 14008 on tackling the climate crisis. And even though it doesn't say EJ in the title, fully the final third of this executive order was all about EJ. Importantly, it was the first executive order issued since 1994 that actually modifies parts of 12898, that original President Clinton executive order. It did a few things that extended that paradigm shift of recognizing that the White House really needs to be in the lead for advancing equity and justice. So a few things that EPA had been leading for a long time, such as the Interagency Working Group on Environmental Justice, that was renamed the Interagency Council on Environmental Justice and has been shifted up to be chaired by the chair of the Council on Environmental Quality. And the big thing that it did here that we're working on right now is it developed this initiative called Justice 40. And this is where this administration is really looking at the trail that has been blazed by the states, here particularly California, where in California, when they had their climate tax, and they had this huge new revenue stream from that climate tax, they dedicated that 40% of the revenue from that climate tax would go to certain communities, and they used their CalEnviroScreen tool to actually delineate which are those communities. So Justice 40 does something kind of similar, not the exact same thing, because we don't have just a huge fund of money sitting out there to be reappropriated or reallocated. We have thousands of pots of money across all of the federal government. Again, this extends that all of government approach to advancing equity and justice. So what we are doing right now is we're actually in the kind of middle phase of implementing Justice 40 across all of the federal agencies and departments. It's a pretty simple mandate. It's 40% of the resources of certain programs must benefit disadvantaged communities. But if you just look at that really simple mandate, right? The resources of certain programs, so which programs, that's what we're actually figuring out right now, which programs benefit. What in the world does benefit mean? How are we going to calculate that? Is that money? Is that staff hours? Is that pollution cleaned up? Is that access to resources? Is that, how do we calculate benefit, and how do we calculate that all up together? So that's the next thing that we're going to figure out. And then the CEQ and the Office of Management and Budget, another White House office, they're also coming up with a way of determining which are disadvantaged communities, which is a huge departure. That is a huge step forward from what we've done at the federal level. Again, borrowing from what is happening not just in California, but numerous states such as New Jersey. Looking at something like EJ Screen, our nationally consistent screening tool. EJ Screen very specifically does not draw borders around communities and label them as EJ or not EJ. And that's not a limitation in the tool. That was a policy decision made in previous administrations, because we didn't really have a policy question we were looking to answer by actually labeling communities. And without a policy question, we weren't going to take the privilege of defining communities. We feel that is the right of communities. In Justice 40, though, with the advisement of a lot of EJ leaders across the United States, the president and vice president have chosen to take this step forward and actually use that sort of data, the sort of data New Jersey is using, the sort of data California has used, the sort of data that's in EJ Screen. They're going to come up with a tool that uses that sort of stuff and actually labels disadvantaged communities for making these really weighty decisions, right? Before in the federal government, we've used these things to kind of get into decision-making processes, to kind of inform us, to do engagement, to figure out how to analyze for EJ. This is going to shift our use of that sort of data and those sorts of tools, not to just be at the beginning, but to be in the middle of our decision-making. We're going to actually drive decision-making, in this case of Justice 40, around resource allocation, by using that sort of data and that sort of a tool. So this is a big step forward for the federal government. And I think once we start doing that with resource allocation, I think you're going to see then that similar sort of application happen in other policy realms. Levels of protection, levels of cleanup, enforcement, what sort of policy decisions we make in rules or in permitting, such as in New Jersey's example. And again, that is why New Jersey and the work they're doing right now is so great and is so instructional, not just for other states, but for us at EPA to really watch, as Sean did such a great job of laying out just how they've worked through it, and the senator, how they've worked through it, who they've engaged with, how they answered these questions, the things they're considering, very, very deftly navigating some tough space, and really one of the most important spaces in EJ terms coming up with how to understand disproportionality and cumulative impacts on communities, and then make actual, decisions, environmental public health decisions based upon that. We can go forward one more slide. A few other things that are happening. So the very first memo that Administrator Regan put out to the entire EPA was his commitment to environmental justice, where he said from his first days, let's go. Let's get out there on enforcement. Let's start incorporating EJ into everything we do. We're going to make it we're going to center our mission at EPA on environmental justice. We're going to start engaging more with communities, and we're really going to work this Justice 40 thing hard. So from his first days, the administrator has signaled very clearly that this is going to be one of, if not the driving consideration of his administration. You can go forward one. The next thing that's happening kind of alongside this is that the president, in addition to the executive orders, has made a huge request for a massive and unprecedented investment in environmental justice at EPA. So we've gone from a budget that has been around $10 to $12 million ever since I've been at EPA for the last 8 years as the director of the EJ program. We've been at about $10 to $12 million a year for EJ. This bumped us up almost to $1 billion. About $600 million of that would go to other programs around EPA, to Superfund for doing some more cleanup, for water infrastructure stuff, for the enforcement program to get out there and make sure we're doing some really aggressive, rigorous enforcement for EJ issues in EJ areas. But it also gives about $300 just to the Office of Environmental Justice, and recommends that we elevate the Office of Environmental Justice into a national program so that it would stand shoulder to shoulder with the Air Office, with the Water Office, with the Research and Development Office, which is pretty exciting. So this is all over at the Hill right now. And we'll see with the American Jobs Plan and the other reconciliation package, and then with the fiscal year 22 budget, we'll kind of see how all this shakes out. But it's a pretty exciting time with folks at very high levels, the highest levels, recommending that we finally start putting the resources to the practice of environmental justice that we have needed for so very long. If we go ahead one slide. And one of the things that Congress says back is that, well, we're already going to give a down payment on this. They gave EPA $100 million in the American Rescue Plan, the bill that the senator referenced earlier, which has had a lot of great impacts on expansion of broadband. $50 million of that was just for environmental justice. I said, we typically have operated on a $10 to $12 million a year budget. So in one fell swoop, they gave us almost 5 years worth of funding all at once. So we didn't spend all of that just in the EJ program specifically, because there were 4 statutes mentioned in the American Rescue Plan in the environmental justice section. So we looked at which four programs at the United States use those statutory authorities. They were the Diesel Emission Reduction Act, the Brownfields Program, Drinking Water, and Clean Air. So we've had a really, what I think is a really awesome effort across all of EPA to look at what are the existing grants or contracts or other vehicles that we have, because this is to respond to the COVID crisis and the disproportionate impact that COVID has had on communities of color, low-income communities, and indigenous communities. And we've looked across the board and have found, up to about 50 or 60 different vehicles out there. Again, grant programs, contract vehicles, other ways that we can move resources out onto the ground to actually start doing stuff, technical assistance, working on drinking water systems, supporting community efforts to monitor and to organize and to educate. So a lot of these different ARP dollars are coming out right now, will be coming out over the fall into the winter. They gave another $50 million just to our AIR program. They're going to have a grant program coming out in a couple of months where communities will be able to apply for up to $20 million to do air monitoring in communities. There should be set-asides in there. Some of that money will just be for communities. Some of that money will just be for tribes. And then some of that money should just be for state, local government. So a lot of efforts, again, looking at the impacts that COVID has had, and particularly on the EPA side, looking at the disproportionality that COVID has had because of air pollution and because of lack of access to drinking water. Those are the things that we're pushing this money out as quickly as we can to have an impact on the ground across the United States. If you go ahead one more slide. And then in the strategic plan of the agency, which is a boring thing, hardly anybody ever reads it. But once you're in an agency, as I'm sure many of you all know, the strategic plan is pretty important. So in EPA's next multi-year strategic plan, there's a core goal on environmental justice. We are working through what all we are going to commit to, not just for my program, but for the entire agency in this strategic plan on environmental justice. It is very prominent in there. I believe by about the first or second week of October, we should be putting that plan out for public comment and feedback for about a month and a half. So if folks want to look at that when it comes out again, October, kind of early November, this plan will be out there for folks to take a look at. And I'm hopeful that we're going to have some very ambitious, some very strong commitments in there where people will see, reflections of many of the things that we have had in conversation today. And I think that's my last slide, Chris.
That is the last one for you. Thank you, Matt.
Right.
Very, very informative. And if I can invite the other panelists to come back on quickly. We're starting to run up against the clock a bit here, and I want to get time to all of the chat questions. But just a couple quickly. Sarah, I thought the presentation you gave on the various state actions right now was extremely informative, but did you get a sense during all your research as to how far along each state was in their individual programs as far as compliance and monitoring?
Yeah, that's a great question, Chris, and I'll try to answer it really succinctly for time purposes, because I think it probably does have a short answer, which is it's early days. I think no one could underscore that better than when Commissioner LaTourette went through just the work he's done in the last year to go through all of those stakeholder meetings since the bill was signed. For example, Maine, who just enacted their legislation, they still have several months left to even come up with a definition for environmental justice and frontline communities. And of course, that definition will be really foundational in terms of how they implement this bill. So it's very early days. Some states are out in front in terms of developing these interagency working groups and developing these mapping tools. But as I mentioned at the end of my presentation, the nuances in terms of implementation about the substance, how we define key terminology, the scope of projects or facilities that may be included in decision-making, whether cumulative impacts will be covered, that remains to be seen in a lot of these pieces of legislation. So we'll have to check back maybe in a couple of years. Hopefully not too many years, but I think down the road a bit, we'll have to check back in.
Absolutely. And on that point about state collaboration and communication with each other, I know everyone on this panel could probably jump in on this one a bit, and I invite you to. But can you speak as to the level of collaboration that's going on right now? And also, just to follow up on your last point, the potential importance to, if possible, standardizing these definitions across various states, various environmental justice area, and if that would actually make this more accessible and limit the, I don't want to say burden, but burden on the regulatory community.
Oh, can I jump in on the collaboration point? I think I heard. So I'll jump in on that, and then would love to hear from my co-panelists on the other parts of those questions. I want to give a kudos to EPA here. EPA has, just as I'm going to use a phrase that Matt used, which is making up so much ground. The Biden administration is making up so much ground here. The efforts at public participation that EPA has put forth in the last few months has been nothing short of tremendous. I get a lot of notifications when there's a public open meeting for these things, and I'm getting a lot of those notifications. And the reason I think it's important is by facilitating those free and open dialogues. EPA, I think, is hopefully establishing, and state agencies too, hopefully establishing some type of routinized pattern of communication between these community stakeholders. And that's going to start to erode some of the transactional costs that I mentioned before, that's been traditionally a problem for getting these communities together to facilitate and promote collective action to advance environmental justice causes. So the more we can start to erode those barriers, the more we can start to facilitate that communication, the better. We see national level environmental organizations also serving a role here. Whereas before they might have been traditionally solely focused on conservation, they're now making environmental justice a core part of that mission, and they can bring national level expertise to bear. They can look at what's working across various offices or states or programs and try to spread it out throughout the country. And I'll give a plug for the academic community as well, particularly law school clinics. I see a huge uptick in the interest of the academic community facilitating this work as well. And so promoting best practices across the country in that way.
Sean or Matt, is there anything you want to add on that one?
I'll defer to Matt here.
I was listening to Sarah and then I forgot there was something in the first part of your question, but now I've forgotten what it was, Chris.
You put me on the spot. No, I have to actually remember too. No, I was asking about the importance of potentially standardizing that.
Oh, that's what I want. Yeah.
Cost
Yeah.
of
Thank you
everything.
for that. Yeah. So that is a huge thing. So a couple things that we're doing. One of the other things that was embedded in Executive Order 14008 is they are contemplating at the White House a full update to Executive Order 12898, the original EJ Executive Order. And one of the things that they have taken a lot of comment on, both from the White House Environmental Justice Advisory Council, as well as other agencies and departments, is how could the US government, not just EPA, start standardizing some of this language, standardizing these definitions, the tool they're going to put out. And then at EPA as well, since we have the largest EJ program and hopefully a much larger EJ program very soon, one of the things we're working very hard on right now, although we haven't really gotten a lot of those resources yet, that's the sort of thing that the American Rescue Plan, we can't use the money for this, but we're working really hard to actually stand up guidance and training, not just for EJ personnel and other personnel at EPA to understand EJ, but everything we are building, we're doing it from the outset to make it public, to make it shareable, and to make it as useful as possible for as many people as possible in state government, in local government, in academia, and business and industry, so that we can try to provide some leadership, again, at setting that floor for everyone else to start building up from.
Thank you, Matt. And for time constraints, I think we're going to jump to the chat box now. I had one here that just came in. Are residents of environmental justice areas being included in economic parts of the bill? Black contractors are only awarded 3% of government contracts, most likely less within the environmental sector. So I guess, Matt, that's yours.
I mean, in terms of the executive order, that's one of the reasons why, even though it's a lot of work, the president gave us a lot of work with all these executive orders. There's several others that touch on equity and justice as well. It's great work because even though Justice 40 itself might not get to the issue of like procurement for cleanup services in Superfund, that's exactly what Executive Order 13985 gets at, is how are we advancing equity through things as mundane and banal as procurement practices, right? Because there's other efforts out there to push that forward, but we've never really held ourselves accountable to it. So whether it's through the executive order or what gets reflected in our strategic plan coming up, that's what a lot of us at the federal level are really pushing, is to have that sort of transparency and accountability to doing things just like that. Where are we spending our money? Where is that benefit going? Who's receiving it, and how is it ultimately benefiting the communities most impacted?
Thank you. We have another one here for Sean, I think. They're asking, are the various airports included in definition of major source of air pollution? And will the offshore wind ports that are currently being developed potentially fall under major sources and have impacted EJ areas?
Yes, so I think is a really good question. Now, what qualifies as a major source of air pollution is anything different than what's in the Clean Air Act and in New Jersey's Air Pollution Control Act, right? So it's effectively a Title V facility, right? So to the extent that there is a Title V facility located upon an airport, located upon a port facility, yes, it would be covered. But I think that this gets at the bigger question of transportation emissions being a huge contributor to adverse impacts that we see in EJ communities and port communities in particular. And there's a number of ways that we're working to get at that aren't necessarily part of this legislation, but are parallel efforts under our executive order here in the state and a number of our incentive and regulatory programs.
Okay, Sean, one more for you, I think. How does New Jersey determine or analyze the additional incremental burden of projects to already overburdened communities? Is there a quantitative framework for this individual stressor, or is it qualitative?
Yeah, so I think that we need to, in order to really answer that in a robust way, when we unveil our data analytics tool, I think that will be more readily apparent. The question between what we're aggregating versus what we are individually assessing and weighing, I think is more the question there.
Understood. And we're starting to get up on the time a little bit. I'd like to encourage all attendees, if you still have questions, to put them in the chat box, and I will make sure that they are actually answered potentially at a later date. I'd like to offer each panelist now an opportunity for a couple closing thoughts. And let's see, volunteers, go first.
I'll go first since I went last. Thank you, Chris, and to the other panelists. I'm actually running, I need to run to another meeting where in another state, somebody has done something on EJ and the business community is not as happy about it as Sean referenced the business community in New Jersey working along with him about. So I'm gonna run away to a meeting with some business leaders who I hope I can help understand exactly what EJ is and why these things are happening and what they can do to proactively engage with us on advancing EJ. And one of the things I like to share, whenever I talk to business and industry, I always bring up what is happening in New Jersey, because I think it is a great example of this isn't just a good thing for folks to do, whether you're in government or academia or the private sector. This is the way our society is heading. It's not EPA forcing it. It's not a single state forcing it. You know, looking back at what has happened over the last couple of years, actually addressing equity and justice and connecting it to the history of systems of racism and oppression and the fact that it's our responsibility to make these changes. It's something that our society is moving towards. And the sooner people realize that and start acting in a way that embraces equity and justice, not only will the better off their bottom lines be, but so will the communities and the rest of us for having a more just society.
I don't think we could end on a better point than that. I really agree and echo what Matt just said in so many ways. I think that point is so important, that this is where society is headed, and I think there's space here for the regulated community to look ahead and see what's coming and get involved in that way.
Sean, final thought?
I think there's an instinct that many of us have that we've carried with us through the course of the application of modern environmental law, this idea that we can have environmental improvement, environmental protection, or we can have economic development. And it's a choice, and you only get to pick one. That's always been a false choice, right? We don't need to dichotomize the issue. And doing better for our neighbors, we don't have to view that as somehow impinging upon our abilities to run a good business and have a successful economy. I think we need to look at our thinking on the issue, right? We're in the midst of cleaning up from a storm that was supposed to be mild, by the way, and just none of them are going to be anymore because science is real and climate change is a thing. And that storm, a lot of folks lost their finished basements and they're going to recover quickly, but a lot of families on first floor apartments in floodplains lost everything they have. I think that's environmental justice, or justice to be done. And we all get to be a part of that, and we don't need to take shots at each other in the process. There is a way for everyone to succeed, and by by lifting one another up, I think we do that, right? There's only one way we do this, and it's together.
I'll definitely echo that. And with that, I think we're coming to the end of our webinar. So I'd like to thank all the panelists again for today for participating. And please note all attendees, you'll get an email from the NAEP office within a few days with a webinar recording along with a brief survey, and we encourage you to participate. And thank you again, everybody. I think it was an excellent couple of hours.
Thank you all, and thanks again, Chris, for organizing this.
Thank you so much. Thank you to Chris especially. Thank you.
Thanks, Chris. Thanks, everyone.
Take care.